Welcome back. The KwaZulu-Natal Personal Injury Association has criticised the Minister of Transport for introducing a draft amendment bill to the Road Accident Fund. It says this poses a grave threat to the rights and well-being of accident victims across South Africa and that the changes are an assault on justice. Dave Campbell, co-chair of the association, joins us now for more. Thank you so much, Mr. Campbell, for your time here on Newsnight. Let's just start with some context. Perhaps you can just tell us exactly what the mandate or the duty of the Road Accident Fund should be.
Good evening, Annalie. Thanks very much for having me. It's important to remember the history of the Road Accident Fund was in the past you would have a compulsory third-party insurance system where drivers were compelled to purchase insurance privately to cover themselves and indemnify themselves in the event of an accident. Around about the mid-90s, the government changed this to say that instead of having to purchase private insurance, they would effectively collect what in all intents and purposes would be an insurance premium by adding a levy onto everyone's fuel. The thought process being that's the fairest and most effective way to collect that premium because the more you drive, the higher risk you are, and effectively the higher your, shall we say, insurance premium will be. And the purpose was for the fund to ensure that any innocent accident victim would be properly compensated. Subject to some restrictions, you would be entitled to what you would have been entitled to in law if the fund didn't exist, and if you sued the wrongdoing driver personally. And this was replaced at some stage by the Road Accident Fund, who would effectively step into the shoes of the wrongdoing driver and you'd claim from them instead.
So that was to make sure that, you know, when drivers who had committed an offence or an error and caused an accident didn't have insurance, that the accident victim would still have some access to recourse and compensation. Now, usually amendment bills come about as a result of a need for fundamental change. Was there anything in the Road Accident Fund, in your view, that necessitated amendments?
Not at all. The Road Accident Fund had already taken away your rights to pursue the wrongdoing driver, and in exchange you were given the guarantee that you would be able to claim from the Road Accident Fund itself. In 2008, they introduced further restrictions by limiting what we call general damages, which is a lump sum figure that deals with things like pain, suffering, loss of the amenities of life, disfigurement, etc., would only be paid out in those cases where your injuries were classified as serious. And they also, further in 2008, capped the amount that you would receive for loss of income such that the higher income earners wouldn't receive full compensation. So they really made significant reductions to the amount that could be claimed. And certainly I don't believe there's any need or it's certainly not desirable to make further restrictions.
What are some of the fundamental changes proposed by the draft amendment bill that you find cause for grave concern?
Well, as an example, currently if you were involved in an accident, in what we call a hit-and-run accident, where you were unable to identify the owner or the driver of the vehicle, you would still be able to pursue your claim with the Road Accident Fund. This they intend removing completely. They intend removing general damages completely, no matter how serious or devastating your collision, your accident is and its effect on your life. You will receive nothing for general damages. They intend removing what we refer to as special damages, which are things like past and future loss of income, past and future medical expenses, and just replacing it with what they refer to as a social benefit. Now, they don't define what that social benefit is and how much that would be or how it's calculated, but effectively they seem to be taking away both your general damages and your special damages and leaving you with an annual annuity payment of an amount they are free to decide at some future stage and publish in a regulation. Yet at the same time, continuing to collect the 45 billion rand a year that they currently receive from the fuel levy to fund the payments to victims, and no indication that that amount is going to be reduced.
So that was going to be my next question, is to talk around the finances of the Road Accident Fund. And as you said, they collect around 45 billion rand annually through the fuel levy. In 2021, the figures looked roughly like this: 26 billion being spent on claimant compensation, 17 billion on administrative costs, 10.6 billion on legal costs, and about 2 billion or more on medical costs. That means that they would run in arrears of 12 billion annually. We know the financial situation of the Road Accident Fund has been in chaos for a while, so surely there is a need to better administrate the Road Accident Fund. These claims might achieve that, but in your opinion, is there a better way to achieve solvency for the RAF without removing protection of the rights of innocent road accident victims?
Yes, certainly. The fuel levy traditionally is increased each year to adjust for inflation. The last year they failed to increase it any further. But in my mind, the chaos that reigns at the Road Accident Fund is responsible for huge amounts of wasted costs. There are various protections built into the Act. For example, once a claim is lodged, there's a period of 120 days in which before an attorney is allowed to issue a summons. And the purpose of that was that the Road Accident Fund would make a fair and just offer. And there's a provision in the Act that if the RAF makes an offer and the plaintiff or their attorney refuses to accept it and proceeds further to trial and would eventually be awarded less than the offer was made to them, then that plaintiff would be responsible for the Road Accident Fund's legal costs from the moment that they receive that offer. So that's an extremely effective method for the Road Accident Fund. It would just mean they have to give a fair and reasonable offer. And then the plaintiff wouldn't have the need to spend years of litigation to compel them to make that offer. And yet that is virtually never used by the fund. Only on the day of the trial, after all the costs have been wasted, after all the medical experts' fees have been wasted, will they finally come up once they've exhausted all their other avenues of avoiding finalising the matter and make a fair offer.
This draft amendment bill would really impact the most vulnerable in society, those who have no funds to otherwise pursue justice for themselves or for their family members. You are asking for public participation. What is the next step in this process?
Well, this draft bill took myself and indeed all my colleagues that I've spoken to completely by surprise. It came out on a Friday late afternoon, and there doesn't appear to have been any consultation with any attorneys, advocates, or medical practitioners, at least, representing the plaintiffs. We have 30 days to file our comments or objections to the Act, which would end on the 8th of next month. So I would suggest that people submit their comments and objection. There's 2 email addresses provided in the draft bill, and also I believe on Dear South Africa website. They've also set up a mechanism to allow the public to express their views.
Well, thank you so much for your insights into this issue. That was Dave Campbell, co-chair of the KwaZulu-Natal Personal Injury Association. As he tells us there that until the 8th of October, that's when there has been time allocated for comment on this draft amendment bill to the Road Accident Fund.